Article 3, Section 1. Common interpretation by Richard W. Garnett and David H. Strauss. Article 3 of the Constitution establishes and empowers the judicial branch of the national government. The very first sentence of Article 3 says the judicial power of the United States shall be vested in one Supreme Court. In such inferior courts, and the Congress may from time to time ordain and establish. So the Constitution itself says that we will have a Supreme Court, and then this court is separated from both the legislature, Congress, and the executive, the President. It is up to Congress to decide what other federal courts will have. One of the first things Congress did in 1789, the year the new government got going, was to set up a federal judiciary, including the Supreme Court with the 6 justices. Today, we have a 3-level federal court system: trial courts, courts of appeals, and the Supreme Court, with about 800 federal judges. All those judges and the justices of the Supreme Court are appointed by the President and confirmed by the Senate. Why did the framers guarantee that we would have a Supreme Court unless the Constitution was amended? A very difficult thing to do. But leave open the possibility that there would be no other federal courts depending on what the politicians in Congress decided. The answer tells us something about the debates and the time the Constitution was written. To some people in the United States at the time, the federal government seemed almost like a foreign government. Those people's main loyalty was to their states. The federal government was far away, and they did not feel that they had much of a say in who ran it. If you thought that way, extensive sitting federal courts, staffed by judges who were appointed by the President and who might not have a lot of connections to the state and its government, amount to allowing the foreign federal government to get its tentacles into every corner of the nation. Other framers, though, thought that the federal government could not be effective unless it has courts to help enforce its laws. If everything were left up to state courts, states that were hostile to the new federal government might thwart it at every turn. The compromise was that just as the Constitution and the federal laws would be the supreme law of the land, there would definitely be a Supreme Court. So the court created by federal government with judges appointed by the President would get the last word in case state courts did something that was too threatening to the new nation. But the extent, the shape of the rest of the federal court system, the degree to which the federal government would be present around the nation, would get hashed out in day-to-day politics. The result is the large, the powerful federal judiciary we have today. The second sentence, Article 3, Section 1, says the judges, both of the supreme and inferior courts, shall hold offices during good behavior, and shall at the stated times receive for their services a compensation which shall not be diminished during their continuance in office. It's pretty clear what's going on here. This provision is designed to make sure that the judges are independent. They can decide cases according to what they think the law requires, without worrying about whether some powerful person or even a majority of the people will object. As Alexander Hamilton put it in the Federalist number 78, judicial independence is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws. The language about holding offices during good behavior has been interpreted to mean that the only way federal judges can be removed from office is if the House of Representatives impeaches them and the Senate convicts them of treason, bribery, or other high crimes and misdemeanors. Only 15 judges have ever been impeached, that is, formally accused by the House of Representatives, and only 8 have been convicted and removed from office. For practical purposes, any judge who does not commit a crime or do anything equally bad has lifetime tenure and will stay in office until he or she dies or voluntarily steps down. And as the provision says, Congress and the President cannot retaliate against judges by cutting their salaries. Most state court judges, unlike federal judges, are elected, not appointed, and some have to be re-elected or approved by the voters every few years. So the system of elected judges are often criticized just because, unlike the federal system, judges might think they have to do political popular things or build up political connections in order to keep their jobs, even if that means ruling in a way that does not follow the law. Very few people think that federal judges should be elected. There are, though, some critics for lifetime tenure. Those critics see that lifetime tenure causes judges to stay in their positions longer than they should after they have become too old to do their job. Well, either just because of age or because they are out of touch with the modern times. Maybe, these critics said, judges should be appointed for a fixed term of years, say 14 or 18 years, with no chance of being reappointed. They still could not be fired, and since they would have to leave at the end of the term, they would have no reason to shape their rulings in a way that pleases powerful figures or popular opinion. But a change like this would almost certainly require a constitutional amendment, and the chance of its happening is extremely small. Although the guarantee that judges will have lifetime tenure seems simple, it actually raises a difficult question in our system. In the federal government, there are many officials who do judge-like things. Think of military court-martials, for example, but who do not have the lifetime tenure that Article 3 seems to require for federal judges. Many of these officials are members of or work for administrative agencies, what is sometimes called the federal bureaucracy. Officials like this will rule on whether, for example, a company has used advertisements that it deceive consumers, or the business has wrongly tried to prevent its worker from joining a union, or the government has not paid a person the disability benefit he or she is entitled to. Thousands of decisions of this kind are made every year by federal officials who are not considered judges for purpose of Article 3 and therefore do not have lifetime tenure, but who are doing the kind of thing judges usually do, settle disputes between people. These administrative officials usually serve only for a few years, after which a president can replace them. There are safeguards to prevent officials of this kind from being openly biased or unfair, but because they are appointed so frequently, they are often thought to be more responsive to day-to-day politics than judges are. Why do we allow this official to resolve disputes in a way that judges do, even though they do not have the lifetime tenure guarantee that judges have? The answer is complicated, but the basic idea is that you generally have a right to appeal from a decision of one this official to a judge whose independence is protected by lifetime tenure. So judges, including potentially the Supreme Court, will have the final word. And then the Supreme Court has said is enough to maintain the principle of judicial independence enshrined in Article 3. Matters debate. The first perspective is judicial power and the power of judicial review. by Richard W. Gurnett. The Constitution is clear about who has judicial power of the United States. The federal courts do, not the president, not the Congress, and not the states. It's less clear, though, when it comes to what that power is. What is it? In other words, that is, the Constitution gives the judges of the Supreme and inferior courts to do. We can assume that these judges do not have the power to enact legislation. The Congress has the federal legislative powers, or the power to enforce the laws that the Congress enacts. That is the president's job. So again, what is that federal judges do and do not have the power to do? One part of the answer is easy. The federal courts have the power to decide certain cases and resolve certain controversies in a neutral and objective way by interpreting the relevant laws, applying them to the relevant facts. However, what if the question before the judge has to do with the legality of the government's actions or the constitutionality of the rule or law? Here, things get more complicated. Alexander Hamilton famously wrote in the Federalist number 78 that the judiciary is beyond comparison the weakest of the federal government's three branches. This is because, he thought, the judiciary has no influence over either the sword or the purse. It has neither force nor will, but merely judgment. True, he admitted, the courts have to exercise what we now call judicial review and decide whether or not legislators and officials' actions are consistent with the Constitution, which is, after all, the supreme law of the land. But this doesn't mean they are superior to the other branches. It simply means that all branches and officials of the federal government are constrained by the Constitution that we, the people, established. This explanation did not satisfy everyone at the founding. Some critics of the Constitution said that the power of judicial review would enable the courts to mold the government into almost any shape they please. It is still debated today. After all, it is one thing to see that courts may and should interpret the Constitution and strike down laws or official actions that are inconsistent with it. But what if Congress, or the president, or state legislators and governors disagree with the court's interpretation? A branch of government that gets to decide what other branches may or may not do, and that gets to overturn policy choices made by elected and accountable branches hardly seems like the weakest. Yet judges are independent, and the founders saw that this independence would protect their ability to uphold the law, even when doing so is unpopular. On the other hand, this independence can look like unaccountability. It can create what the great legal scholar Alexander Bickel called counter-majoritarian difficulty. Throughout our history, many of the Supreme Court's most contested decisions have been cases, think of cases involving, for example, gun regulations or abortion restrictions, where the judges struck down duly enacted laws and created contempt acted against the will and legitimate choice of the majority. Our written Constitution means that some such cases are probably inevitable, and at the same time, our commitment to democracy means that they are and will continue to be controversial. Next perspective, not your founding father's judiciary, by David A. Strauss. Section 1 of Article 3 is a cornerstone of our legal system. It established the Supreme Court. It is the basis of the federal court system and served those purposes from the very beginning. At the same time, though, when we read this part of the Constitution and many other parts of the Constitution too, we can see how much things have changed since the nation was founded, in ways that the framers of the Constitution could not have predicted. The framers were prepared to have a country in which there are only one federal court, the Supreme Court. With that word, the nation we live in today, anyone who had complained about anything about unlawful discrimination or violation of the right to free speech or police brutality would have to go to state court. The state court judge might be appointed by a governor or even a mayor or might be elected. That would all depend on state law. State law would decide what kind of jury, if any, that person would get. You would ultimately have the chance to ask the U.S. Supreme Court to hear your case, but the Supreme Court is just one court that can only hear a relatively small number of cases each year. That is not the nation we live in today. Now, it is important not to underestimate how much state courts do even today. Even today, when we have extensive federal court system, state courts decide many more cases than federal courts by far. But while the rules that determine when you can get in federal courts can be complicated and technical, federal courts are often available for people who think they have been deprived of their federal constitutional rights, for people with other kinds of claims too. At the times in our history, federal courts have been havens for people who were victims of discrimination in the states where they lived. Another time, federal courts have been accused of being in the pockets of lawyers for the wealthy and privileged. But the inferior federal courts other than Supreme Court, have been tremendously important in the history of our nation, even though, as far as the framers were concerned, those courts might never have existed or might have played only a small role. Another way in which the framers of Article 3 did not foresee the future is, in anything, even more remarkable. As we said in our joint statement, there are a lot of federal officials who do judge-like things, but are not judges who have the life tenure required by Article 3. To a degree, the framers of the Constitution did know about that. If you think about it, even an ordinary police officer acts a little like a judge. She will listen to your excuses and then decide whether to give you a ticket. There are no federal police force when the Constitution was adopted, but there are tax collectors, customer inspectors, and army paymasters, and they all had to make some decisions that were a little judge-like. What the framers could not have foreseen was that someday there would be thousands of federal employees like that, hearing millions of cases, often in formal settings that resemble courtroom trials. Excuse me. Important federal programs like Social Security and Medicare could not operate without employees like that, but although these employees make decisions that can have a big effect on people's lives, acting in many ways just like judges, they're not Article 3 judges, and do not have the protections or the prestige that the federal judges have. The practical accommodation our system has reached, as we said in the joint statement, is that these decisions can be appealed to federal judges who do have life tenure and ultimately can even go to the Supreme Court. If you just read Article 3, Section 1, you won't see any of that. But this hugely important part of the federal government reflects another of the many ways in which our Constitution is not just an unshakable foundation, but a flexible institution that can adapt to the needs of a nation and the world. that are in countless ways different from what the framers knew.